Okay.
Yes, good evening to everybody. Welcome to the today class of the Advanced Private International Students. And the last class that I was dealing about the cause of action. And the last part is left over there, which I want to complete it later on. That I will start the jurisdiction. And please read what I posted on the screen so that both are sailing the same boat to the same destination. Please read what I posted on the screen. Anyone?
Basic principles of private international law.
Good. Go ahead.
Choice of jurisdiction, choice of law, recognition and enforcement of foreign judgment.
Repeat. Repeat. I said repeat.
Column 1, choice of jurisdiction,
Good.
choice of law,
Good.
recognition, enforcement of foreign judgment.
These are the basic three principles in the private international law is there. And next class that we are going to do the choice of jurisdiction, but we have dealt to choice of law earlier classes. Now let us come to the point of our choice of law. When it comes over there, there is a classification. There is a two where it is decided. Classification of the cause of action number one, and a classification of the rule of law. Can you tell me what is the classification of cause of action? Yes. Can you tell me what is the classification of cause of action? If you know it, you tell me. If you don't know it, you just pass on. Hurry up.
Classification of the cause of action. This depends by classifying the cause of action on which cause of action it matters. Maybe it may be in a tort, for example, defamation or breach of contract.
I appreciate. Then what is the classification of the rule of law? Anyone?
Classification in the rule of law, it refers as to the what kind of law is governing.
That means whether the lex loci, whether lex fori should be followed over there or lex loci would be followed over there. So which law should be followed over there to give the justice to the party? Because it is the full logical reasoning of the judges to decide it. And there is no hard and fast rule in this regard. So that was the two things that we decided. And this generally the classification of rule of law applicable in the case, we discussed this case law. There is a Gharib Abdullah Juma versus K. Milinga in our earlier classes. I want to make it very much clear when you are writing. When you write generally, after generally, you have to keep the comma. Otherwise, it is a mistake. Are you following me?
Yes, Professor.
When you write generally, you should write the comma. When you write the therefore, you should write the comma. So there are commas we should have to not forget him. Otherwise, they'll say that, oh, this man doesn't know where to keep the comma, where to give the full stop. So, shall we deal again the Gharib Abdullah Juma versus K. Milinga, or shall we go to the jurisdiction? It is choice is left to you. Please. Give me the answer. I repeat, Shall we deal again the Gharib Abdullah Juma came Linga case law, or we can skip it because we already taught in the earlier classes? Option is yours. Unmute and give me the answer.
We can skip it, Professor.
Okay. Because I will give the full facts of the case law, and case law, I will send you it independently to you, the full judgment. You can read it and see how the classification is made, whether the choice of law is concerned or whether the rule of law is concerned in that case law. Now let us see the jurisdiction. What is meant by jurisdiction? So, when you say as a jurisdiction, the first question in the international case potentially involving the conflict law problem is in which the court has a jurisdiction in adjudicate the matter. And the same thing that we studied in this posting also. What is the first one? What is the first one?
Choice.
Yes, it is a choice of jurisdiction. Do you know what is by adjudicate? Do you know what is meant by adjudicate? Please give me the answer.
The power.
Adjudicate
is the power.
Disposal of the case, judging the case, deciding the case. That is called jurisdiction to adjudicate the matter. Although the plaintiff decided where to sue, the courts in that location may not have a jurisdiction, or they have the jurisdiction but be unwilling to exercise it for reason of forum non-convenience. What is meant by forum non-convenience? Participants. What is meant by forum non-convenience? If you know it, you tell me. If you don't know it, you say pass on. Don't waste the time. Participants. Are you hearing me, participants?
Yes, Professor, I can hear
you. Not giving the answer. Say pass on, I will give the answer.
There's no hard and a fast rule.
I say what is meant by forum non-convenience? That's my question.
Pass, sir.
See, in all the disputes of the private international law, plaintiff is given a higher important role under the placement also. Because if any breach of contract is happened in the Kenya, let us presume it, and the contract is concluded in the Kenya, and the breach happened in the Kenya, but the plaintiff is from the Tanzania, and the defendant is from Kenya, it is difficult for the plaintiff to go and file a case in Kenya, and hence the court will give the discretion to the plaintiff where he stays, where he is comfortable, where he can file a case, where he can attend the court. That is called forum convenience. That is. When you say forum non-convenience, means it is difficult to file a case in a particular place because the court will see that it is difficult for the plaintiff to prove it. At that time, we can say the court says the forum non-convenience. But the most of the places where the plaintiff stays over there, and that place, the court will allow to file the case, even though, to strictly speaking, there is no such a jurisdiction to file in Tanzania. It should be filed only in Kenya. For instance, in your domestic law, if any murder or a rape or any other criminal offenses happen in the Mwanza, could you file case in the Dar es Salaam? Participants, give me the answer.
No.
Why?
No, Professor. Because Mwanza is where the cause of action has happened.
The cause of action is happened in the Monza, and hence the court in the jurisdiction of the Monza, in which area it will come, and that court will entertain it. But before the court entertain it, who will make a complaint? A complainant will make a complaint regarding the offense, and which police station having jurisdiction where the cause of action happened over there, that police station will make a first information report, or they will make in a diary to inform to the respective jurisdiction where the court, where the cause of action arises, and where this court is having jurisdiction to entertain the case. But generally, depending upon the magnitude of the offense, the nature of the offense, either it can be filed in the primary court. Suppose if it is filed in the primary court, the murder case or the rape case, the primary court doesn't have a jurisdiction, and it will be commuted to the which court? It is commuted to the which court? The domestic.
Resident Magistrate Court.
The primary court doesn't have the jurisdiction to entertain the murder case. It is commuted to the which court?
It will go to the
It is
Resident
commuted
Magistrate
to the
Court.
district court. Because district court is another words also say the sessions court. It means it will entertain the criminal cases. But the most of the civil cases and the simple criminal cases, sometimes it will be handled by the civil cases in a district, it will be handled by the
Magistrate.
Residence Magistrate Court. That is the right answer. Say again.
Resident Magistrate.
Yes, why you are, see, it's a simple thing, the domestic law that I am speaking over there. So now let us see what are the jurisdiction of in the law. When you say why the law, jurisdiction is an important factor. So the authority given by the law to a court to try case and rule to legal matters within a particular geographic area, and virgule, that is a slash, are over a certain types of the legal cases. So in the geographical area where the cause of action is there, and that particular court is having jurisdiction to entertain, and that depends upon the nature of the case law, which court will entertain it. So why jurisdiction is important in law? Read the answer. Anyone? Unmute and read. Why is jurisdiction important in the law? See, again, I magnified it so that it will be visible to you.
Jurisdiction is important because a court does not have jurisdiction over a case. It does not have the legal authority to pass judgment on the case.
Yes, jurisdiction is important because if a court does not have the jurisdiction over a case, it does not have a legal authority to pass a judgment on the case. As I told you, can the election commission case will be entertained by the primary court? Answer, no. When the election commission case will be entertained by the resident magistrate or the district magistrate court, answer is no. Then which is court is having the jurisdiction to entertain the election cases? Yes. Yes, give me the answer. Election cases will be handled by the which court in Tanzania?
Professor, are you there?
getting to hear something. I wasn't.
Pardon? That cases will be handled by the High Court, the original jurisdiction it is having. Suppose if a person is disappointed by the decision of the High Court, then he should approach to the
Not hearing anything. What you're discussing, I was just looking at the screen. I was not hearing anything.
Yes, you are giving the answer. It is a private talk.
Prof,
We were saying we were not hearing anything. I was here, but I was not hearing anything. I was just seeing the movement on the screen.
Doesn't matter. I will give the answer. Okay, mute it. I will give the answer. If it is not happy with the High Court, then one will go to the Court of Appeal. So, what is the jurisdiction is example? So, jurisdiction is defined as a power of authority to decide the legal cases. And an example is jurisdiction is a court having the control over a legal decisions and about a certain group of towns or certain group of the geographical area and cities and where the jurisdiction will stand over there. So that is the meant by jurisdiction. Can governing law and jurisdiction be different countries? The answer is the choice of governing law needs to be the same as the choice of forum, and the parties can choose different jurisdictions depending on the type of the disputes. And however, for obvious reasons, it is usually sensible to make them the same. For instance, in the law of contract, sometimes the party will choose a different country jurisdiction, neither the plaintiff country nor the defendant country. Can they do so? Yes. Participants, anyone can unmute, give me the answer. Did you understand the question which I asked? Say yes or no.
no, sir.
Say a party from the Tanzania, another party from the India, they made a contract and they made an agreement in the contract stating that if any disputes will be there like a breach of a contract, then we will approach the Kenya, and a Kenyan court is having the jurisdiction to entertain such a case. Can your party choose the jurisdiction in that manner or not? That's my question. Yes. If you know the answer, you can give me. If you don't know the answer, you can say pass on. I am giving you the nice weapon to you to defend yourself. Yes. Please give me the answer. Say pass on if you don't know the answer.
Pass on.
Why you are taking that much time to say pass on? Okay, now I will give the answer. Answer is
network problem.
Answer is yes. They can choose the jurisdiction of the other country, even they don't belong to either the plaintiff will belong or the defendant belong. In our example, plaintiff from the Tanzania and the defendant from the India, and they have chosen the Kenya as a jurisdiction. They can do so. For instance, I will give the explanation. Admiralty jurisdiction means marine disputes, means vessels disputes. Are you following me? Do you know what is meant by vessels disputes? Marine disputes, sailing disputes, where the ships are used, where the vessels are used, and it will be sail on the water. So, if the two countries, they can choose because the law in England is more advanced than the India. The law is more advanced than the Tanzania or Kenya. And which law? England law. Because marine law is well developed in that country. So, these two countries will say that if any disputes are raised in the sailing matter, in the marine matter is concerned, at that instance, it is the English law, English court, or the England or UK having the jurisdiction to entertain such a case. Yes, answer is yes. Now let us go to the another point. What are an exclusive jurisdiction clauses? Exclusive jurisdiction clause in the sense the party agrees to submit to the exclusive jurisdiction of a particular court or the country. Now this means that the parties know exactly where the dispute will be brought and what the national procedural rules will apply in the event the dispute arises. Sometimes the parties will make the exclusive jurisdiction of a particular country because it is the choice is given to the parties to choose the jurisdiction. Now, if any dispute arises between the candidate or student of the South, Mwanza, and the student, and which court is, where is the place, and where the court is entertained if any disputes are there? Yes, between the South and the candidates, if any dispute arises, which jurisdiction and which court is having a jurisdiction to entertain the case law? Please give me the answer. If you don't know, say just pass on. I will give you the answer. Don't waste the time.
The district court.
It is the Mwanza court, respective court, depending upon the nature of the case law. The Mwanza court will entertain such a dispute because it is clearly written in the prospectus. Please read. So, what is the jurisdiction in Tanzania? The answer is the High Court of Tanzania was established under the Article 107 of the Constitution, and it has an unlimited original jurisdiction to entertain all type of the cases. The High Court exercises original jurisdiction on the matter of the constitutional nature and have a power to entertain election petitions. I already asked the question. If any election disputes are there, which court is having the jurisdiction to entertain such a case law? Participants.
The High Court.
High Court of Tanzania having the original jurisdiction in the constitutional matters are concerned, including the election petitions. Is it clear? Say yes.
Yes, sir.
Yes.
Now you tell me, how many types of jurisdiction in Tanzania you will study it? Yes. How many types of jurisdictions? It is not a hard question. It is a simple question. If you know it, answer. If you don't know it, you say just pass on. The weapon
4 to 5.
Defend yourself.
I do remember only 5 jurisdictions.
Can you tell me what are the 5?
Original jurisdiction.
Okay. Okay, because there is a problem, I think, with your Matanda. I will give the answer, don't worry. See, appellate jurisdiction, number 1, pecuniary jurisdiction, number 2, territorial jurisdiction, number 3. These are the generally the 5 broad categories. Now you read. Anyone can unmute and read? One. I think only one person is reading. I don't know what happened to the other people. Please go ahead.
What are the jurisdictions of primary court in Tanzania? Or
I said just 3 jurisdiction. I read the 3 which is there on the screen.
appellate jurisdiction, pecuniary jurisdiction, and territorial jurisdiction.
Can you explain what is appellate jurisdiction?
Appellate jurisdiction, this is the jurisdiction for a court that will handle appeal matters.
It is an appeal jurisdiction means from lower court, people are dissatisfied, going to the higher court is called the appellate jurisdiction. Then what is pecuniary jurisdiction? Anyone?
It is the jurisdiction that goes with the amount of money that is with the case at hand. So if it is maybe 50 million to 100, district court, 100 million to maybe 300 to 400, it's high court, then it goes like that.
Yes, I appreciate your answer. I appreciate. Then what is the territorial jurisdiction?
This goes with the geographical area of a certain place. So yes, maybe if it
I appreciate. Because you need not to give the full answer, because your 1 or 2 lines will give the answer that you know the answer. So now let us see what are the jurisdiction of primary court in Tanzania. Of course, this is a simple question. The primary court has the unlimited jurisdiction over the property held under the customary law and in the matter of the Islamic law. And this jurisdiction is vested in a particular court in the exclusion of any other court. But generally, the primary court, as you said, the pecuniary jurisdiction, okay, limited power is there. After that, it goes to either the residence magistrate court or it goes to the district court, depending upon the nature of the case. If it is a session court and the criminal matters are concerned, generally it goes to the district court. But one of the case law that we will see, this case law gives the jurisdiction in the Tanzania. Can you read the case law name, which I am highlighting here? Anyone?
I haven't done that.
Scova Engineering, SPA, Arctic, SPA.
Okay, because there is a you mute. You mute because there is a break of voice. You mute. Yes, Sova Engineering SPA and Airtech SPA versus Mitibua Sugar Estate Limited and 3 others. This is civil case number 133 of the 2017 Court of Appeal, Dar es Salaam. And let us see what is the jurisdiction of the High Court in this case law. So, High Court jurisdiction is provided under the 108 Sabbatical 2 of the Constitution of the United Republic of Tanzania 1977 as amended time to time. What is URT? What is meant by URT? Anyone? What is meant by URT? United Republic of
Tanzania.
Yeah, why you are taking so much time that you are taken, because 3 times I repeated, but you did not give the answer immediately. But anyway, it doesn't matter. The article vests in the High Court with powers to deal with that matter, which, according to the legal traditions obtained in the Tanzania, we can say that under section 2(1) of the Judicature and the application of the Laws Act of the Cap 358 revised edition 2002, that is called JALA. JALA means Judicature and the Application of Laws Act, and the CAT means Court of Appeal of Tanzania. Therefore, only the confirmed disposition and confirmed the law, it says about the jurisdiction. So what I want to say here is, for instance, you take the Sunshine Furniture case, and the party based Tanzania realized that forum chosen the High Court of Justice of England is London, because there chosen the London as a jurisdiction. And the Scova Engineering case and the based in Italy. Please mute. I'm getting the sound. Please mute. I'm getting the sound. Scova Engineering case parties, it is based on Italy. And they are saying,
sorry, bro.
Yes. And they say it's Italy. Do you want to say anything?
I'm sorry. I'm having very serious network problems. So I've just heard you from this last time, and I don't know where you're reading. So you have lost me.
See, here I am highlighted. Is it visible?
Okay.
Is it
Yes,
visible?
it's visible.
So
Yes, I'm having a serious network problem.
each company having chosen the different jurisdiction. Like Sunshine chosen the London, England, and the Scova Engineering, because it's the Italy-based company, they have chosen the Italy. And the Tanzania counterpart in the court of Rome, they say Italy. While the defendant they are based in Tanzania and they have assets in Tanzania, and this may seem unjust because underscores the importance of the sanctity of the contract. Now the contract is made between the three or four, but the defendant is from Tanzania, but the plaintiffs are from the different countries, and their companies are different countries, and they chosen the jurisdiction. One is chosen the England, there is the London, UK, another choosing the Italy, there is the Rome, but the defendant is from the Tanzania. In such a case, it is clearly mentioned in the contract. At that instance, whether the High Court is having the original jurisdiction to dictate the terms to the parties, even though you have chosen the different country jurisdiction, but it is not feasible to the plaintiff because the plaintiff is from Tanzania. At that instance, even though you have chosen, but the Tanzania is having the jurisdiction to entertain such a case because the statute clearly mentioned in the Constitution that High Court is having the original jurisdiction to entertain the case when the cause of action is in Tanzania. At the time, High Court of the Tanzania is having the jurisdiction to entertain, even though the parties made the jurisdiction of the different countries. That is the gist of this case law, which I want to say. I don't know how far that you understood the case law. Did you get any point? Did you get any point?
Yes, Professor.
Yes.
That means when the parties have chosen the different jurisdictions of different countries, when the plaintiff is from Tanzania and his assets are in Tanzania and his business is in Tanzania, even though the contract is concluded in a different place also doesn't matter, but the cause of action has happened in the Tanzania. At that instance, High Court having the jurisdiction to cut down the other party's jurisdiction and they entertain only the Tanzania jurisdiction. Why? Because plaintiff is from Tanzania, having the business in Tanzania, having the assets in Tanzania, hence appropriate jurisdiction is Tanzania. Hence, even though the party has chosen the different jurisdiction, that will become a null and void. Even the High Court having such a jurisdiction. So that is the gist of the case law. So the CAT means Court of Appeal in Tanzania, decisions recaps how courts of Tanzania can entertain a different jurisdiction. So that is the gist of that case law. Now let us see the rationale behind the choice of jurisdiction. See, this is that I am making. So when you see the rationale, there are several factors that affect the plaintiff decision of where to file a case. So I told you already, even though the party has chosen the jurisdiction, but still the court gives the discretion to the plaintiff to file a case because it is a forum convenience and the plaintiff should not be suffered under the private international law where the judges give such a convenience to the plaintiff to file a case for where he could be comfortable to file a case. So now it is one is convenience that is called forum. For example, read this one. Example, anyone? Unmute and read, which I highlighted. Anyone can unmute and read which I highlighted. For example, participants, are you with me?
A plaintiff is likely to want to sue in a jurisdiction that is reasonably close to his home.
Okay, there is a problem, I believe. Okay, I will read. Mute it. A plaintiff is likely to want to sue in a jurisdiction that is reasonably close to his home. I had already told you, which is his home and where he is based, where his transactions, where his assets, where his business, where his agriculture and everything. Particularly because witnesses and evidence may be more readily available there. So that is the first advantage. And the legal question also are important here. What is the legal question? Let us see here. A plaintiff may be more likely to file a suit in a jurisdiction that will afford him procedural other advantages and where the defendant has assets with which to satisfy the ultimate judgment. For instance, plaintiffs also having the assets in the, let us see, in Tanzania, and the defendants also in the assets in the Tanzania. At that instance, even the cause of action happened in the Kenya, it doesn't matter. A plaintiff have given you such a chance that the forum convenience to file a case in, to file a case in, to file a case in Tanzania. Example of likely to procedural matter here I said, and this thing which I am going reading. For instance, like example of likely to the procedural or a substantial advantages include the possibility of the jury determination damage in tort case. It is easy for them because witnesses are available, and even though cause of action is somewhere, cause of action happened in the Tanzania, then it is more likely that witnesses will give it and the Tanzania law would be applied over there because it is having the close connection with that transaction. And the availability of the punitive damages in case of the tort is concerned, the ease of obtaining the pre-trial discovery of the evidence commonly used in the United States or any other country. If the damages are likely to be happened over there, then the damages should be available. I told you already in my last class, if any accident happened in Tanzania by the defendant from the Kenya, then the close relationship is there in Tanzania. But if you use the Tanzania law, the damages are only limited. And if you use the Kenyan law, damages are unlimited. At that instance, what is the two aspects I told you? One is the cause of action, another is the rule of law. At that instance, the rule of law will be changed. Which law country would be used over there? The example which I have given just now.
Kenya.
Why? Why? The reason is Kenyan law, if you could use it over there, it doesn't have the cap, means ceiling. Unlimited damages are there.
Because the law punishment is unlimited.
Yes, that's why I told you it is the reasoning of the judge to replace Lex Fori with the Lex Loci. Is it clear?
Yes, sir.
Yes.
That is what I want to say. And the place of suit is not entirely up to the plaintiff. So now the chosen court must have the power to entertain the case, jurisdiction or adjudicate. The jurisdiction grant will usually be defined by the statute. Generally, jurisdiction will be defined by the statute. But in case of the giving justice to the plaintiff, and the court will change the jurisdiction also. So in addition, the exercise of the jurisdiction may also be limited as a check on the statutory grant And of course, what I want to say here is, it is the court will decide to see which jurisdiction the case will be entertained. Why? It wants to give the more priority to the plaintiff and who is going to file a case. Because he is more comfortable in the Tanzania, let him file in the Tanzania. If it is more comfortable in Kenya, let him file the case in Kenya. Are you following me?
Yes, sir.
Now let us see this case law. This case law will give you a good example. Can you read the case law which I highlighted? Can you read the case law?
We had. Yes, yes, Professor. In a Piper aircraft versus Reino, a suit filed in the United States on behalf of Scottish parties whose relatives were killed in an airplane crash. The flight originated in Scotland and was scheduled to end there. The aircraft was owned by a British entity. The pilot was a Scottish, and all of the relatives were Scottish, only the defendants.
The aeroplane manufacturer is only the defender, that is the Piper, and the propeller manufacturer had a connection to the United States. But all other parties are Scottish. But actually, it is happened in the Scottish. So they said the Piper manufacturer and the propeller manufacturer had the connection to the United States because of the plaintiff sought a remedy that were not available, at least not to the extent desired under the Scottish law. So they decided to bring a suit in the United States, making this a clear case of forum shopping. Why it is given a forum shopping here? Because the defendants and who are the plaintiffs here, and they are from the United States. So it is a choice given to them to defend themselves, and instead of Scottish law, they are using the United States law because of the forum shopping, because it is a convenience to the party to entertain the USA rather than the Scottish law. So who will decide? Who will decide which is the jurisdiction? Yes? Who will decide? It is the reasoning of the judges and who could decide which country law would be applicable over there, even though the cause of action happened in the Scottish and the rest of the other people from the Scottish, but only the two people from the USA, but more better with the USA law rather than the Scottish law. So that is the forum shopping will be given by the court. Now let us see the civil law countries generally don't dismiss action for the reason for the forum non-convenience. So it will not.
Sorry, Professor, could you repeat who would decide?
Please repeat.
Yes, could you repeat who would decide? I did not hear anything.
Yes, it is the reasoning of the judges. That means court.
Okay. Okay.
It is the reasoning of the judges. It is the court which will decide which is the forum shopping and which is having the jurisdiction to entertain such a case. Because to give the justice to the party. In the private international law, a person who comes to the court when there is a cross countries matter is there, at that instance, the person should not go with the empty hands and the person should not be disappointed. So the court will see that a justice should be given, be bestowed, and it seems to be bestowed to the party who approaches the court. And as I said already, There is no hard and fast rule to say that which country law could be applied and which court jurisdiction it should be entertained. It is solely decided by the judges, the court. Is it clear?
Yes. Yes.
So now, still we do have 2 or 3 minutes, 5 minutes are left over there, but we can complete this jurisdiction. Each country determines the jurisdiction of its court to entertain a civil lawsuit. Do you agree? Answer is yes. Because each country is a sovereign country, and they say this is the jurisdiction of our country, and where the court of appeal will to entertain the entire mainland of Tanzania, including Zanzibar. Are you following me? Say yes.
Yes, sir.
So now, let us see that if it is the United States, yes, the entire United States. United Kingdom, yes, entire United Kingdom. Tanzania, both mainland as well as the Zanzibar. So they do have the jurisdiction to entertain the entire geographical area. If any case is decided, that will be holding in the entire country. If it is decided by the Court of Appeal, the decision will be followed in the lower courts also. Now let us see, most countries allows the party to agree to the jurisdiction of a court. So it is the court will decide which jurisdiction a party should have to file a case. Consent may take from an express agreement in the initial business contract at the time of the dispute arises. Sometimes the dispute arises over there, they will decide it, which country law could be used over there. At that instance, the High Court doesn't interfere in that matter because they will give the discretionary to the court. Yes, let them file it because it is their dispute and it is their thing. But it in certain respect, when the plaintiff approaches to the High Court, then High Court will interfere it. Then they say the other country's law will not be suitable because the plaintiff is basically from the Tanzania, having assets in the Tanzania, having the home in the Tanzania, having the agriculture in the Tanzania, and hence at that instance court will interfere it. Otherwise, court will not interfere when the two parties agree to entertain their disputes in any other country other than the plaintiff country, other than the different country. Like an example which I gave, in marine matters are concerned, the sea matters are concerned, even the parties are either India and another party from the Tanzania, they can choose the jurisdiction of the UK or the England, because England law is more advanced in the mercantile matters. In the marine matters, in the sea matters, in the vessel matters, when you compare with the either Tanzanian law or when you compare with the Indian law. Is it clear?
Yes, sir.
Here, the last is an example. When neither the parties nor the controversy has a connection to the country in which the court is located, in most cases, however, the court jurisdiction is not an issue. Lucy.